The coronavirus pandemic has led many state governors to put in place orders that force their citizens to quote-unquote shelter in place. For example, Governor Cuomo in New York on March 20th ordered his entire workforce to stay home, saying that it was the most drastic action that he could take. And more recently, on the 30th, Virginia Governor Ralph Northam ordered state residents to stay at home until June 10th, a stay-at-home order of more than 2 months. Very dramatic. And indeed, 37 states, actually exactly 37 states, have put in place statewide shelter-at-home orders as of April 2nd. So that's led many people to ask the question of whether or not these orders, which force people to stay at their homes, are either both legal and or constitutional. For example, Robert Barnes, a prominent lawyer, has said, quote, "If the asymptomatic do not spread coronavirus, at a high rate, then far fewer people have it, and putting those people under house arrest," it's a pretty aggressive interpretation, "makes little public policy sense and is also unconstitutional under existing quarantine constitutional law." So then the question is whether or not these things, these shelter-in-place orders put in place by state governors, pass constitutional muster. And we'll answer that question in today's video. But first, since we're new here, Human Events just restarted its channel. So if you're watching this and you're a fan of my work on Twitter, or you're a fan of the work we put out at www.humanevents.com, do us a favor, hit that subscribe button like I just did there. I know there are people who have fancy graphics. We're just doing it by clicking. So please do that. It would be very helpful to us. We're trying to get this started and put out more content on YouTube. Back to the show. Start by talking about the legal authority just generally under which somebody like Governor Cuomo might implement a quarantine. So this is New York state law right here. Section 28 of the laws relating to state and local and natural and man-made disaster preparedness. It's a mouthful. Section 1, when the governor, on his own initiative or pursuant to a request from one or more chief executives, finds that a disaster has occurred, blah, 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 he shall declare a disaster emergency by executive order. This is very similar to what you see in the federal law where the president can declare a national emergency when there is an emergency. But the more important point is in Section 29A, which is what this allows the governor of New York to do in a national emergency. And it's a really broad power. And so we're going to read through it, but just be patient. This is an immense amount of power. Quote, subject to the state constitution, the federal constitution, and federal statutes and regulations. So he can't violate the state constitution or federal law or the federal constitution. That's the only qualifier. The government may, by executive order, temporarily suspend any statute, local law, ordinance, or orders, rules or regulations, or parts thereof of any agency during a state emergency, if compliance with such provisions would prevent, hinder, or delay action necessary to cope with a disaster. Okay, in short, he can stop enforcing any law he wants to. He can suspend its application if there's an emergency, if he thinks that will hurt the disaster. That's one power, basically, to ignore existing law. It's pretty broad. The second one, quote, the governor, by executive order, may issue any directive during a state disaster emergency declared in the following instances, blah, 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 epidemic disease outbreak. So, one, the governor of New York can suspend the application of laws. Two, he can issue directives under existing state law. So there's nothing that violates New York state law about Andrew Cuomo ordering everyone to stay in their homes in order to fight coronavirus. And that's going to be very common. States have what's called a police power. They have the ability to pass laws to help public health, and that power is, manifests itself in a variety of state laws that give them power to deal with emergencies. So that's the state law side. Let's talk about the constitutional law side, because that's an interesting question. Lawyers like Barnes and others are suggesting that there's a constitutional problem with forcing people to stay in their homes. And intuitively, that's not unreasonable. Think of things like, for example, the Due Process Clause, which says that you have the right not to be deprived of life, liberty, or property without due process of law. That would seem to be implicated by a rule that says you're not allowed to leave your home. That is a significant restraint on your liberty. So there's an obvious question about whether or not these sort of shelter-in-place orders are constitutional. But my reading of it says that they pretty clearly are, and we'll go through it. So let's go through some older constitutional cases. We're going to start with Jacobson v. Massachusetts. That's a 1905 case, and it's actually the latest, I think, of the three that we're going to look at on the constitutional law side. And it's not actually directly on point in terms of quarantines, because it's a law about compulsory vaccination laws. Basically, this is a first case that had the Supreme Court saying it is constitutional for states to say you must get vaccinated. If you don't, you have to pay a fine. And it articulated, as it says, this is actually very description, articulated the view that the freedom of the individual must sometimes be subordinated to the common welfare and is subject to the police power of the state. It's basically a good summation of the overall argument. And I want to focus in on some of the specific language because even though this case is about compulsory vaccinations, it does contain a good amount of language sort of to understand the police power, the authority of state governments to just protect the public and protect the general welfare using the force of government. So, talking again, quoting from the actual opinion. This is the real deal opinion right here. So we quote from the Supreme Court opinion back in 1905. The authority of the state to enact the statute being the compulsory vaccinations, is to be referred to what is commonly called the police power, a power which the state did not surrender when becoming a member of the Union under the Constitution. Although this court has refrained from any attempt to define the limits of that power, it has distinctly recognized the authority of the state to enact quarantine laws and health laws of every description. Indeed, all laws that relate to matters completely within its territory and which do not by their necessary operation affect the people of other states are therefore constitutional. And it's true. The other cases we'll go over show that basically the right to quarantine, the authority to put in place quarantine orders is something that is is pretty much has been recognized by the Supreme Court since at least the early 19th century, since the 1820s, and perhaps even earlier. So that's pretty dramatic. But there's other parts where this case talks about quarantine, even though it's about compulsory vaccination. So, this is discussing just the general principle of quarantine and what happens in normal societies at the time. It is equally true that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. An American citizen arriving at an American port on a vessel which during the voyage there had been cases of yellow fever or Asiatic cholera. It's kind of funny to hear like Asiatic cholera. We'd never refer to something like that. Brief aside. Although apparently free from the disease himself, may yet, in some circumstances, be held in quarantine against his will on board of such a vessel or in a quarantine station until it be ascertained by inspection conducted with due diligence that the danger of the spread of the disease among the community large has disappeared. Next case, Gibbons v. Ogden. This is even older. If you're a lawyer even if you're a law student and you're taking constitutional law, this name will ring a bell because it's one of a very important cases about the Commerce Clause that gives the federal government the right to regulate interstate commerce. But it's also got a whole bunch of stuff about quarantines, and it's back in 1824. It's not a new case, right? So, going to the opinion, reading about quarantine, the police power. Talking about it, what the police power is here. They form a portion of that immense mass of legislation which embraces everything within the territory of a state not surrendered to the general government, right? Again, states, police power. Federal government has limited and enumerated powers, but the states have broad power. That's why there's no federal law against murder, plainly, state laws against murder. Not surrendered to the general government, all which can be most advantageously exercised by the states themselves, inspection laws, quarantine laws, health laws of every description, as well as laws for regulating the internal commerce of a state. That's Gibbons v. Ogden. One of the most important Commerce Clause cases also recognizes that quarantines are inherently part of state authority. Finally, a third Supreme Court case from 1902, Company Francaise. This case is actually factually a little bit more relevant. There was a state law that required the involuntary quarantine of individuals to prevent the spread of disease. This was in New Orleans, Louisiana. Basically, they had a yellow fever outbreak, and they said you can't come into the city if, I'm pretty sure that's the basic idea. Your a cordon sanitaire had been declared on land forbidding the entry of any uninfected persons into the area. And again, when this was challenged and went all the way to the Supreme Court, and the Supreme Court said as follows: that from an early day, the power of the states to enact and enforce quarantine laws for the safety and protection of the health of their inhabitants has been recognized in Congress is beyond question. That until Congress has exercised its power on the subject, such state quarantine laws and state laws for the purpose of preventing, eradicating, or controlling the spread of contagious or infectious diseases are not repugnant to the Constitution of the United States. It's really simple. Guys, this is old law, but it's very, very stable when you keep seeing over and over again the idea that it is obvious that states have the authority to quarantine, and that the Supreme Court continues to say that over and over and over again. I mean, from the early days, like, this is true. Now, you might say, well, what about more recent law? It's like, well, that's where actually things get a little more interesting. There haven't been a lot of quarantine cases. I don't know if there have been any full quarantine cases at the Supreme Court lately. There's not to say that there's no quarantine litigation that ever happens. We've had some recently, as lately as the Ebola outbreak in 2016, I believe. But this is the sort of baseline. That usually was handled in smaller courts. This is the baseline. So let's get back to the question. So Barnes again said, if we can remember, he said, quote, "If the asymptomatic do not spread at a high rate, then far fewer people have it, and putting those people under house arrest makes little public policy sense and is also unconstitutional under existing quarantine constitutional law." So what Barnes is saying is that if there's essentially, if the asymptomatic don't spread it that much, then the shelter-in-place orders that force everybody to stay in their homes are unconstitutional. It's unclear, like, what the actual full argument, like, what is the particular violation, but I can guess. There's a potential due process violation, as we talked about. And there's also some case law, not from the Supreme Court, but from other places, that have talked about how truly arbitrary and overbroad quarantines can be unlawful. For example, a really good description of a quarantine law that was found unlawful is, in this case, Juho v. Williamson. Historically, frightening academic, as this is an article, before we get into that, article from written by Lawrence Gostin, who's actually one of the preeminent authorities on public health law. Let's see, here we go. Juho v. Williamson. One of the most invidious measures in public health history, public health officials had quarantined an entire district of San Francisco containing a population of more than 15,000 persons. Sounds similar, but wait. Ostensibly to contain an epidemic of bubonic plague, quarantine was made to operate exclusively against the Chinese community. That's the problem, right? And the court basically saw that this was just an effect to say, like, the Chinese are not allowed to leave their area, and it was specific. And this was at a time when there was a serious amount of anti-Asian discrimination in California. Quote, "The court held that the quarantine unconstitutional on grounds that it was unfair. Health authorities acted with an evil eye and an unequal hand, and it can be used as an instrument of prejudice." But understand, the key thing here is this isn't a Supreme Court case. This is the CC. I don't even know what that is, but it's a lower court in California. That's what that means. That's not the Supreme Court. That's a lower federal court that sits out probably in San Francisco at the time. And so that's the kind of case where you can actually see it. But that's not that kind of case, something that's incredibly arbitrary and overbroad. That's the kind of thing that might be found unconstitutional. But there's a second problem. Not just the fact that you'd have to prove that it was so arbitrary, a quarantine was so arbitrary that it was like Juho v. Williamson. But also there's the problem of qualified immunity. So I'll explain that very simply. So qualified immunity is a doctrine, and this is Wikipedia. It's a legal doctrine in United States federal law that shields government officials from being sued for discretionary actions performed within their official capacity unless their actions violate a clearly established federal law or constitutional right. So let's break that down. What is this? Why does it matter? Okay, so government officials are routinely sued for what they do and their actions all over the country, oftentimes in what are called civil rights actions or Bivens cases. Somebody who feels like their constitutional rights were violated by a police officer or somebody can go to court and sue. And the courts have fashioned this doctrine called qualified immunity to give a little more freedom and a little more coverage to government officials who are trying to apply the law in good faith. And so what they say is government officials aren't liable unless their actions violated, quote, clearly established federal law. So if, for example, they were, an opinion says that it's a close question, but we think that in this case, these actions violated due process, that wouldn't be good enough to hold a public official liable. They would have to violate clearly established constitutional laws. So let's take an example, right? If an overbroad quarantine, a slightly overbroad quarantine, maybe a court might say that's a little too overbroad, but then they'd have to go to the follow-up question and see whether or not it was obvious under current law, by previous cases that a reasonable person would think it's obvious that that was unlawful. It's just not the case with something like a quarantine of somebody who's asymptomatic. If you're looking for something that wouldn't have qualified immunity, a case where somebody just decided to completely arrest someone without probable cause at all, that would be a clearly violation of qualified immunity. If a police officer decided to start beating someone on the side of the street for no good reason, not in self-defense, that would not, that's not a clear question. That's not clearly, they're violating pretty clearly established law. So, that's the kind of case where you actually see qualified immunity come into play. But things like this, I don't think it would be very viable. I don't think it would be a good argument to say that the quarantine law in the United States is clearly established. And I'm not just speculating on that. There have been quarantine cases that have come down this way. So a really interesting one, quarantine of Casey Hickox. So this is, again, that Gostin article. Quote, Casey Hickox, a nurse who treated Ebola patients in Sierra Leone while volunteering for Doctors Without Borders, was the first individual quarantined under New Jersey state Ebola policies. They quarantined her for 3 days in a tent on hospital grounds. New Jersey released her to Maine. Maine then placed her in a quarantine. These quarantines, quote unquote, according to the opinion here, flouted CDC guidance. And that's, that's actually an aggressive argument. But let's talk about how the court eventually resolved this. So the court ultimately, came down to say, first you have to know we have to question whether or not this violates clearly established law, right? So it says here, the qualified immunity analysis is two parts: to determine whether the facts and inferences therefrom establish that the official violated a constitutional right. That's part one. And then part two, the court must determine whether, as a legal matter, the right that the defendant's conduct allegedly violates was a clearly established one that a reasonable person would have known. Okay. So, quarantine case law. So they look at the precedent to look at whether or not somebody has the power to enforce a quarantine. Again, this is back in dealing with Ebola. This is actually analysis of the federal government, which has the power to do this. And as well, states also have the power to do this. So it says, the modern era, the CDC has played a supportive role. The states are taking the lead. And that's what happened here. After initial screening at the CDC, the state of New Jersey took over. And Ms. Hickox was detained pursuant to state law and citing an administrative rule. And it says that under Jacobson, Company Française, and Ogden, the Supreme Court upheld exercises of the state's general police powers to protect public health through quarantines and other measures. This is just simply old law. And, it accounts for, again, courts have sometimes struck down quarantine orders when they were found to be arbitrary and unreasonable in relation to the goal of protecting public health, and talking about Juho v. Williamson. And so in this case, Hickox argued, the plaintiff argued, that the initial decision to quarantine her did not bear a real or substantial relation to the protection of public health, but instead was arbitrary and professive. And the judge argues that while he sympathizes with Hickox's plight, that they cannot find her isolation violated any clearly established constitutional principle embodied in quarantine law. And I think this is the part that I think is really important, because it applies to what we're talking about today. Quote, of course, even as to a dread disease, it is possible to overreact, as it was with cholera and yellow fever. So it is with Ebola today. A restriction can be so arbitrary or overbroad as to be impermissible. The parties cite no case striking down a quarantine order, however, that is this close to Hickox's factual scenario, or that would have clearly indicated to any of these defendants that their actions violated established law. Moreover, Hickox was returning from treating patients in a country then ravaged by an Ebola epidemic, thankfully now under control. The disease is a very serious one, and there's no vaccine or medicine to prevent or cure it. Like, for example, coronavirus right now. There's no vaccine. It's a novel virus. The state could reasonably have thought that prevention and containment were therefore paramount. It's really simple, guys. There's a massive amount of Supreme Court case law saying that the states clearly have the authority to quarantine. There are occasional lower-level cases where a low-level federal court has thrown out an obviously over-aggressive and discriminatory quarantine. Juho v. Williamson is a good example of that. But in general, when you're dealing with a virus where there's no known vaccine or cure, and when you're dealing with a situation where there is just a reasonable basis for what the government is doing, or it can be an overreaction, but if it's not absolutely absurd, you're not going to win an argument that it's unconstitutional. And so, arguments like Barnes that say under existing quarantine case law, this would be unconstitutional just because asymptomatic people don't spread at a high rate, it's not good enough. If there was proof that asymptomatic people simply do not spread this disease, that might be something. But we've seen plenty of evidence that asymptomatic people spread this disease. There's one of the reasons it is spread so virulently and so aggressively across the entire world. the shelter-in-place orders may be over-aggressive, maybe an overreaction. I don't think so, but even if they were a moderate overreaction, they're going to be found constitutional if it ever got into court. And that's essentially the problem. Not just are they going to be found constitutional, but they're certainly not going to be found to be an unreasonable and clearly established violation of constitutional law. So that's what I got for you. Thank you. Again, if you're new here and you enjoy this, please go to the Human Events YouTube channel, youtube.com/human events. Hit subscribe and keep following and share this one out. Like, we're trying to do more content on a regular basis, so I think this is a big part of it. Thank you so much. Thank you for watching, and I'll see you tomorrow.